exactly what happens today.
I can
That's the
explain that.
confusing part.
Sharon is with the Department of Human Services Office of Child Support. So
Yes, I'm the Child Support Director, and I've been the director since 2004, and prior to that I was legal counsel, so I've been around child support for 30 years. This bill has been introduced 3 times, and we've supported it, and Director Hawkins has provided written testimony. What happens today is this, and I'm responsible for the voluntary acknowledgment program in Rhode Island. The child support program is responsible for that. We've had a voluntary acknowledgement process in place since like '97, but in Rhode Island, even before it was federally required, we were doing a voluntary acknowledgement process since the mid-'80s. So my office, along with the Office of Vital Records, works very closely with the birthing hospitals, and we develop the forms, and we have the pamphlets, and we run the program. So at this particular time, what is happening is we, along with the Office of Vital Records, is struggling with these issues. We need to pass this law so we can address these issues. Right now, if a child is born of a marriage, whether it's a same-sex marriage or a heterosexual marriage, that child is presumed to be the child of those parties. So those 2 names are added to the birth certificate. That's not the issue when it's a same-sex marriage. The issue comes about, as all of these people have already described, is when you have a same-sex couple who is unmarried, they are unable to fill out the voluntary acknowledgement of paternity. So their names cannot be added to the birth certificate under the current law. And as I think it was Ann said, you could really get someone off the street. If there was a heterosexual couple and the male was acknowledging paternity, his name could be added to the birth certificate. There's no requirement that DNA be performed or that any notice be given. He's there, she's there, they add their name to the birth certificate. Obviously, if the mom was married at the time of the birth of the child, the husband is presumed to be the father of that child. Otherwise, this individual who's a male could have his name added to the birth certificate. So we right now are struggling. The hospital staff is asking us, what do we do with these cases? I can't give them that type of advice because at this particular time, only the mom's name can be added to that birth certificate, and then they're required to go and do a costly adoption.
So if the couple is married, no matter what genders they are, the couple is married in the state of Rhode Island, both parents are added to the birth certificate.
That's correct.
At the birth.
At the birth.
Okay, is that enforceable everywhere in the United States?
So parentage is a rebuttable presumption, and so gay couples
Keep bringing that up.
can fight over the fact, if I were married to Sharon and we had a baby, we'd be separated, and she would say, your name's on the birth certificate, but you're really not the parent, and I'm taking custody away from you because you're not the parent of that child. Children conceived during a marriage are deemed a child of that marriage, even if they're not of that marriage. That's for heterosexual couples and homosexual couples. So that's what we tell gay and lesbian couples today. Even though you're married and your names, both names are on the birth certificate, you still have to go through the adoption process to secure the non-biological parents' rights.
Okay, thank you.
The other issue that we're struggling with right now, and Lisa explained it very well earlier, is when you have a surrogate, and that surrogate gives birth. Years ago, we would have a pre-birth order, and that pre-birth order, maybe it's 2 males or 2 females, they would bring that pre-birth order to the hospital, and hospital records would add their names to that birth certificate. That practice stopped. This Parentage Act would codify that, so we would have a procedure in place for that type of a situation, and there would be a pre-birth order that could be entered pursuant to the Act. So those are the 2 issues that we're really struggling with the voluntary acknowledgement process.
Thank you very much.
Okay. The other couple of things I wanted to mention briefly is one other issue that the hospital staff has been talking to us about is the last name of the child. The Rhode Island Parentage Act addresses that the child can be named any surname that the 2 parents choose. Right now, there's a little bit of a conflict between the state law and a Supreme Court decision, and they are very uncertain about what to do in that scenario. So we've just advised them in the meantime to allow the parents to name that child any surname that they, deem appropriate. So the
Does
department...
it have to be one of their surnames? I mean, if you have
The
Jones and
parents-
Smith come in,
The
does it have to be
parents
Jones and
would
Smith?
choose.
But they can pick
Whatever
from
last
only one of
name
those two.
they choose, that's
Okay.
correct. And there's been a little bit of a controversy. This bill would codify that. This act also incorporates provisions of the current law that we do like. For example, it allows us to pursue past liabilities for a period of time on behalf of the custodial parent against the non-custodial
You're talking
parent.
about child support.
Yes, I
Sharon,
am,
right?
yeah. And contested paternity cases where we're establishing paternity, it allows us to go back 6 years prior to the filing of the complaint. We also can seek reimbursement for the cost of genetic testing. So we also worked with Vlad on this bill, and we made sure that there were some of those provisions in Rhode Island law that we do like and that are working that would remain. So the Department of Human Services certainly supports this bill, and we urge passage.